welcome back. Just down. Okay, welcome back. I will be done grading your exams tonight. You'll get back tomorrow. I don't know what time. Terry has to print them out. We'll be back sometime tomorrow, okay? I'll
pick them up tomorrow?
Yeah, you'll pick them up tomorrow.
Okay.
From you?
No, from Terry May, her office in the 8th floor. I'll give you the room number.
Okay.
But I'll be grading them tonight, and they'll be done tonight. Okay, almost done. And I'll try to go over a little bit at the end of the class if I have time. Okay. Questions? Questions? Anything in your mind? Yeah, Carlos.
This is what I directed class, but for me the Doodle application wasn't working to put on my date. I don't know if anybody has like a similar problem.
I have over 140 people signed up, so try a different browser. It's not perfect, the Doodle, but it's better than putting a piece of paper on my wall. So yeah, I've actually pushed to the limit. The Doodle software is not working well because there's so many damn. I don't think it's meant to handle this many students, but it's managing okay. The first round of meetings are going to be on a Saturday morning. Okay. Any questions? Okay. Oh, by the way, let me mention this. So, on the exam, there was a question concerning the property clause, which you might remember. I'm joking. There was actually a lawsuit filed yesterday by the federal government against the state of California, saying that it violates the property clause. You think I'm making this stuff up? This is actually relevant. California passed a law which made it a crime to engage in certain types of land transactions unless California approves of them. So say someone sells their property to the federal government. California says, unless you give us, California, the right to buy it also, you can't make that transaction. The DOJ filed a lawsuit saying that violates the property clause of the Constitution, which gives Congress the power to dispose of property. You think I'm giving you relevant stuff? You are ahead of the curve. You're probably the only lawsuit in the country who had the property clause in their midterm, but you're in the game. Okay, anything else? All right, let's start with a question. It's not a hard question, but it may make trip people up. Right? This is my baseline question. So, assuming most of you have driver's licenses, wrong class property. Okay. So the question says, State A allows 16-year-olds to apply for a driver's license. State B allows 18-year-olds to apply for a driver's license. Does State B violate the Equal Protection Clause? Another 10 seconds or so. All right, let's try this. Okay. Do you remember where I left up last week? Are you next? All right.
Because, I don't know, I feel like states could choose the driving age for, like, based off safety and what you think, I don't know.
What's the argument of why State A may allow 16-year-olds and State B allows 18-year-olds? What might be, you say safety, what might be a reason why? Give me a little bit more.
State A might think that 16-year-olds are mature enough to have a driver's license, while State B may think that 18-year-olds aren't mature enough.
Ah, that's a reasonable judgment for a state to make?
Yeah.
Do you think State B is being unreasonable by denying licenses to 16-year-olds?
No.
So they're both reasonable positions.
Right.
Greg, let me ask you the question differently. Can a state discriminate on the basis of age? consistent with the 14th Amendment?
No.
They can't. So you think State B is breaking the Constitution? Is violating the Constitution here?
No.
What? Oh, you gave me two answers. Okay, so which one is it? Can a state discriminate on the basis of age?
Well, age is, I guess, a classification that's
It is a classification. You're right.
uses the least amount of people.
The least amount of what?
Scrutiny.
Oh, before we get to scrutiny, we'll get to scrutiny in a few minutes. You're jumping ahead a bit. Why is age permissible to discriminate on the basis of? All right, Stephen. So Malia said something a minute ago. She said that you can make a judgment that 16-year-olds are mature enough to drive, and maybe in other states it's 18-year-olds mature enough to drive. Let me change the facts here, right? Let's say a state determines that, as a general matter, girls are safer drivers than boys. They are, right? If you look at statistic numbers, they're safer. So you say, okay, females can get a license at 16, but men get a license at 18. And if you look at empirical tables, it shows that men are more reckless drivers. Insurance premiums, girls generally have lower premiums at that age than guys do. Would that be permissible? Girls get licensed at 16, guys get licensed at 18. Because they're more safer and more mature.
Like it is peaceful.
You think that'd be okay? Okay.
Basically, like you had said, or just from the other video, as far as the age being like non-suspect, like that there's a big, based on age, like there's usually a rational basis for it, like it said as far as the insurance and accidents or whatever.
So you think that's enough?
Yeah, well, and basically because there's a way to overcome it, like even though the boys can't get it at 15, when they're 16 they can't, like it's not absolute.
So everyone becomes 18 eventually, right? They'll get their license in a couple of years.
Yeah.
Ambrose, let me ask you a third variant of this question, right? What if a state says white people get their license at 16 and African American drivers get their license at 18? What happens with that law?
Well, I don't think that would go.
Why not?
Because I'm kind of going off what he said, not everyone, like he said, everyone will be 18 this time.
What if, I'm making this up, right? What if insurance numbers show that white drivers get into fewer accidents? I'm making that up completely. I don't think it's true, but let's just make it up for a second, right?
Yeah, anything just based on race like that, I don't think it's...
So, no good. All right, so I just taught you guys scrutiny, right? You didn't realize it. I told you I was going to get there. People ask me, when screw up? I do it here, because here it makes the most sense. When you're talking about the Equal Protection Clause, right, you're saying, can the government treat people differently based on a classification? Classification. What's a classification? When the government sorts you and identifies you by your age, your sex, your skin color, your religion, anything you can think of. The court has taught us that certain types of classifications are very suspicious, right? When the government classifies you on the basis of your race, it's very suspicious. Because even if they put forward a good reason, insurance rates, that's probably not the real reason why they're making this classification. Other types of classifications are fairly routine. I use age as an easy example. Why? Because the government all the time makes classifications on the basis of age without any sort of improper motivation. For example, when you get your driver's license, when you're old enough to get married, right? When you're old enough to sign a contract, you say this in contracts, right? If you're under 18, you're incompetent. You cannot sign any sort of contract. You're not liable for those damages. So, why are some classifications considered acceptable and other classifications like race considered unacceptable? Okay, this is where the idea of the tiers of scrutiny come in, right? And they're called the tiers of scrutiny. And you might think of, like, the tiers of a cake, right? You have like a 3-layer cake. But what often confuses students, and will really confuse you in about a week or so, is these tiers blur, right? These are not fixed, rigid, 1, 2, 3. There's often some fluidity, shall we say, between one and the next. But I'm going to teach you the black letters first, and then I'll teach you why it doesn't really matter, right? His name is Anthony Kennedy. You're very familiar with him. He doesn't like scrutiny. He never talks about them, so it doesn't matter. But I'm going to teach you what it was, at least for maybe 20 years or so. So the first step to understand is, what is a classification? And let's just start here, right? Age, right? This is the example I gave you guys a minute ago. When you're classifying people on the basis of age, it's called a non-suspect class. A non-suspect classification. What does that mean, non-suspect? It means we're not suspicious, right? If the state wants to give a driver's license at 16 or at 17 or 18, we don't suspect that any sort of animus might be behind it, because the state usually has very good reasons why they're making these classifications. Okay? I'll give you a second example. Sex, right? Well, this might not be true anymore, but generally speaking, every year I teach this class, my answer changes a little bit. Historically, when the government wants to treat men and women differently, it's sometimes permissible and sometimes not. So maybe where is it permissible? Bathrooms. And again, this is why I change my answer every year. But historically, separating people based on their sex in bathrooms was considered a legitimate state function. What about in public schools? You have a boys' school and a girls' school? Maybe not. So sex was what was called a quasi-suspect classification. I hate that word quasi, but it's everywhere in the law, right? It means it's not quite suspicious, but it's, like Spider-Man, right? Your spider senses are tingling, right? You're on the lookout for like, someone's gonna write an exam, I know it. It's fine, I use it all the time. But you're somewhat suspicious. You're not quite sure that this law, is it actually passed to have a legitimate state purpose, or is it being passed to perhaps discriminate against people on the basis of their sex? And then we have race. And we already discussed race in cases like Korematsu and Brown and Loving, right? When the government is making a classification on the basis of race, we call this a suspect classification, right? A suspect classification. What does this mean? We're suspicious, right? If the government says, well, we'll give white teenagers a license at 16 and black teenagers at 18, insurance tables, you say, well, wait a minute, are those numbers accurate, or are you just doing this because of racism? That's what this idea means. The court didn't develop this sort of framework of what's a suspect classification, what's quasi-suspect, and what's not suspect in one case. This developed over the course of decades, and I'm giving it to you in a fairly concise form, but don't pretend this was any sort of coherent process. The judges kind of cobbled this together over many years. All right, so your first step with an equal protection case is asking yourself, what is the classification? And these are easy examples. There are others. These are the biggies. Is there any questions so far? This part's easy. Okay? Once you've identified the classification, and whether it's a non-suspect, quasi-suspect, or suspect, then you have to determine the correct standard of scrutiny. This you'll simply have to memorize. Okay? When you have a non-suspect classification, you apply what's called a rational basis review. I'll explain what that is in a minute. When you have a non-suspect classification, you need to apply what's called a rational basis review. When you have what's called a quasi-suspect classification, you apply what's called intermediate scrutiny or intermediate review. Review and scrutiny are synonymous. They mean the same thing. The word scrutiny is when you look at something, how closely do you look at it? And think of this like a magnifying glass, right? If you want to look at something, you can take a magnifying glass, right? Or you can look at it with your naked eye. Which will give you a more precise analysis? The magnifying glass, right? So try to think of the rational basis as like looking at it with your naked eye. And then this intermediate scrutiny is like taking out like a magnifying glass, right? Right? You're really looking at it closely, okay? But then you have what's called strict scrutiny. Okay? Strict scrutiny is like using a microscope, right? An electron microscope, right? You're drilling down to the core, and you're looking at every single aspect of that law. You are very suspicious that that the racial classification offered is not the real reason. The purpose of this framework, this rational basis, this intermediate, this strict scrutiny, is for a court to decide, is the reason the government's giving us the real reason? Or is it motivated based on some improper animus? It's never going to happen, right? That a lawyer walks into court and says, Mr. Chief Justice, we are segregating schools because we're a bunch of racists, right? They're not going to say that. They're not going to say that. Mr. Chief Justice, the Lovings can't get married because we want to promote white supremacy, right? They're not going to say that. They're going to give some other reasons. We need to keep the schools segregated to promote public safety, prevent fights. Okay? We need to prohibit interracial marriage to ensure that children are not raised in mixed racial families and that they're going to be bullied in school. Whatever the reason is, you're not going to have someone come and say, you know what, we're doing this to a bunch of racists, right? They're going to give some other reason. The purpose of these various tiers of scrutiny is to enable the court to say bullshit, right? That's not the real reason you're doing this. You're not doing this for public safety. You're doing this to promote a white supremacy, right? And that's why I like the analogy. If you're looking at it with your naked eye, well, public safety, that's good enough, right? We don't want kids who are 16-year-olds driving on the road because they might screw stuff up. They might get into accidents. That's good enough. With the intermediate, well, is it really the case that 16-year-old girls are that much more mature than 18-year-old boys? Is that based on a stereotype or is that real? And here it's like, well, microscope, right? We're looking at this justification of public safety is bogus. Reason. You're giving us what's called a pretext, a fake reason, right? Fake news, right? This is not the real reason why you're doing this. Everyone with me so far? So first you got to identify the classification, right? Is it suspect, non-suspect, quasi-suspect? Then you have to know what scrutiny tier applies to it. Everyone with me? Okay. Once you identify the relevant tier of scrutiny, you're almost out of the woods. Okay. You now need to not only memorize, but understand the tests used for these various tiers. And there are tests for each, and they're applied in a very different way. We've already studied these a little bit in due process. They're very similar, but I want to teach it to you here because it's a little bit easier with equal protection. So the first test goes something like this: that the government policy is rationally related to serve a legitimate governmental interest. The government policy is rationally related to serve a legitimate governmental interest. We've discussed this before, and we've discussed in terms of the means and the ends, right? The means and the ends. What does that mean? The means is, what is your approach? What are you doing, right? What's your law, right? The ends is, what's your policy? What are you trying to accomplish? And scrutiny is about measuring the fit, the connection, the tissue between the means and the ends. Okay? So I'll do it like this. Oops. That's what I want to do. The means okay. So I label this a little bit differently. So what's the government policy, right? That's the law at issue. That's the law that says driver's license for 18-year-olds, not 16-year-olds, right? That's your means. That's what you're actually doing. Okay? Your end is your government interest, right? What are you trying to accomplish? Promoting safe highways. So ask yourself, right? What's the connection between driver's license at 18 and safe highways? Okay? Now, are there going to be some immature 16-year-olds? Of course there are. Will there be some mature 16-year-olds? Of course there are, right? Are some 16-year-olds better drivers than 18-year-olds? Of course there are, right? In any population, you will find someone who's 16 years old and will be the safest driver in the city, and then some 18-year-old idiot doesn't know what he's doing, will drive off the road. Okay? But the essence of rational basis review is the fit doesn't have to be perfect, right? In other words, even if some of the people who are denied licenses would be unsafe, that's enough, right? That if it's a general matter, you can rationalize that some 16-year-olds will be bad drivers, the policy survives. The key word here is this, rationally related. Rationally related. That is there some possibility that a 16-year-old might not be a safe driver? Then you're done, right? Then in that case, the policy of limiting licenses to 18-year-olds is rationally related to public safety. It doesn't have to be a perfect fit. And I described this before in terms of tailoring, right? You can get a suit. You can go to Kmart, right, and buy a suit off the shelf that just hangs on you, but it fits. It's not a perfect fit. Or you can go to a custom tailor, and they'll fit it to your exact proportions. When you're making rational basis review, age-based classifications, you don't need the custom tailor. Kmart will suffice, right? It can hang off your body, they'll keep you warm. Everyone understand that? And in fact, with rational basis review, even if there's no evidence that there are some bad drivers who are 16, it's still enough. Because courts can say, well, you know what? In a rational world, there might be a 16-year-old who's not safe. Good enough. The key word there is it might. There's a possibility that underage drivers are unsafe. Therefore, the government's purpose, safety on the roads, is adequate. Right? So when you're looking at rational basis review, you don't need hard evidence that the government's policy will actually work. It's enough that you can think about that, well, maybe it'll work. Reasonable minds can differ. That's enough. And that's precisely why in Texas you get your license at, 16? And in New York, where I'm from, it's 18. And there's no constitutional challenge to be brought. How's that? Questions on this so far? Everyone with me? Clean? Smooth? Clinton?
So you said this came from multiple cases.
It was developed over decades, yeah.
This isn't just like the zones of 1, 2, 3 tiers.
You think of Justice Jackson?
Yeah, that's not, okay.
Nothing at all to do with it.
So if we were going to quote this would just be based on, what's the citation for this?
We'll be doing cases today, Thursday, and next week and the week after.
But it's not just one, okay.
No. This, again, Clinton posed the question well. This framework was developed over the course of maybe 3 or 4 decades, and it's still in flux to this day. Okay. It wasn't ever written down, like with Justice Jackson's opinion, wrote in one paragraph, right? You don't get that. Yeah. Not so lucky, unfortunately. Yes.
So this framework you cannot use for cases like Prescott or anything like before that.
Well, this framework, I think, officially began with Korematsu. Right, Korematsu is probably the starting point to this, but you don't get cases involving intermediate screens until the 1970s. Right. So we're talking 30, 40 years. So it's a pretty long process. But I like the way you're thinking. Good question. By the way, and I'll mention briefly, students have this tendency to cite Justice Jackson for everything on the exam. It's not relevant for most things. It's utterly irrelevant. If you say, well, Congress passed the bill and the president signed it, that means in the first tier. That's not what Jackson says. You can't have a law unless the president signs it. Right? The question is, does the president have some sort of executive power, some sort of inherent power? That's where you're applying Youngstown. Don't give me, Congress passed the law and the president signed it, therefore in the first year. That's not what Youngstown says. Enough of you wrote that made me annoyed. Every year it happens. In fact, I've actually taught Youngstown less, so you don't start putting that exam. Apparently, didn't work. You spent a lot more time in Youngstown. Apparently, it backfired. But anyway, all right. So everyone with me on rational basis review. Okay. I'm going to jump ahead and let's do intermediate. So the test for intermediate scrutiny has been framed in different ways, and you're going to yell at me. You'll find a Horn book that frames a little bit differently. Sue me. There's no consistent statement of what this law is. This is how I say it, and this is what I'd like you to say, right? So the government policy is substantially related to serve an important governmental interest. And again, I promise you'll find slightly different phrases of this, because the court never says it the same way. They'll change the wording, tweak it a bit, but this is how I like to say it, and you can do the same, you'll be in good shape. So let's do the same thing before. So we have our means. Oh, I keep doing this thing. Okay. Means, the fit, and then the ends. Okay? The means, the fit, and the ends. From one to the next, you'll notice some differences, right? In the first one, it said rationally related. Here it says substantially related, right? Herbie, I'll start calling people again, right? What's the difference between rationally related and substantially related? They're different words, right? What's the difference between rationally related and substantially related?
Well, rationally is about the reasoning, of course. And substantially related.
Which is tougher to satisfy, right? Which one is more precise? Which one requires a closer fit?
Think about right?
Only a 50-50 shot. Bianca, what do you think? Which one, explain why. Which one requires a tighter fit? Rationally or substantially?
I'm also thinking rationally because you need something, you kind of need evidence, you need something to back up over time.
But what did we say rational means a minute ago, Bianca? How did I define rational? Does that have to have actually any real evidence? Right? What will satisfy rational basis review? Do you need to show actual evidence this policy will work? What's required? No, Fernando? This is an important point. With rational basis review, do you need to show actual evidence this policy will work?
I think so.
What do you need to show what do you need to show? What was that key word I used? It was an M word. Very important word. I said it a minute ago. That it blank work. That it will work? Bianca? What? Might. There you go. That's your magic word, right? With rational basis review, you don't have to show the policy will work, that it must work. It's enough to show that it, thank you, might work. That's your magic word, right? It's possible. Maybe it'll work, maybe not. We don't really know, but that's good enough for rational review. But now, I'm sorry, name tag? Kenny, right?
Kenny, yeah.
Kenny, yeah. Came back to me. Kenny, with a requirement of substantial, right? Oh, JC?
For number 2, is that like Buck B. Bell, hashtag science?
Hashtag, yeah. Well, no. Let me ask you, JC. Did Justice Holmes require any proof that sterilizing Carrie Buck will improve the human race?
Yeah, I thought that was what they were talking about, was that they had fake drafts pulled up.
Oh, the family trees, right?
Yeah.
So you raise a good point, right? Let me answer your question this way. Justice Holmes, do you think you really needed those graphs and trees and stuff?
In particular, no. What is it if they want to go to hell? I'll send them there.
Yeah, very good. So the people litigating Buck v. Bell, we're trying to go maybe a little bit higher up. Holmes only needed the first tier. Justice Holmes' dissent in Lochner, right, is this first tier, right? Depending how you interpret it, Holmes' dissent in Lochner is basically this sort of rational basis review, where you don't need any actual evidence. You can basically make crap up at the court. in Virginia, the hashtag science people were actually trying to give something, right? Those graphs and charts. They were trying to go a little bit up here, but they didn't even need that for homes. Very good point. Kenny, not out of the woods yet, right? With might, with a rational review, what's required with intermediate scrutiny? Like what substantial related, what do you have to give? Something more than might? What do you have to give?
Yeah, I would say that you have to show that it's more than likely.
Oh, good word, right? Good word. He said more than likely. Preponderance? Remember this from your Civ Pro, right? Preponderance? That's not perfect, but I think that's a decent way of phrasing it, right? Preponderance, right? Is there some evidence that what you're trying to do will actually accomplish what you want to do? All right? Let's use our examples. We'll make it more clean. Girls get the license at 16, guys get it at 18. All right? What's the government's rationale? Well, we have some insurance tables showing that, females have lower accident rates at 16 and boys have higher rates, so we'll just get their license a couple years later. That may or may not satisfy intermediate scrutiny. I don't think it would. But you have to show something precise, right? How much of a difference is it, right? Is it a small difference? Or is there a big difference, right? Is there such a big difference in their accident rates that it justifies this disparate treatment between men and women? So the key difference there is substantially requires more evidence, more proof. It's not enough that it might serve the interest, but it probably will, or it likely will, or will, right? We can't predict the future. We need some stronger evidence. Okay? Everyone okay with that? Andrew, there's a second difference. So here we see a legitimate governmental interest, and here we see an important interest. What's the difference, Andrew, between legitimate and important? What's the difference in those two words? Important. Which is tougher to satisfy, legitimate or important? Important. Yeah. Right? Give me an example of, something that's a legitimate interest. Well, Andrew, what does legitimate mean?
Something that's just enough or classified as quite enough.
Yeah. Legitimate's a fairly low bar, right? Basically, anything the government wants to do can be legitimate. Think of Lochner, right? Would protecting monopoly bakers be a legitimate interest? Probably, right? Would it be an important interest? Maybe not. So this difference between legitimate and important is subtle, but it suggests what the government's trying to accomplish has to be more important. Now, someone's raised their hand and say, wait a minute, Josh. How do you draw the line between legitimate and important, right? How are you going to draw the line between rationally and substantially? These are court-created tests. They're not precise. What you need to understand, though, is that it's harder to satisfy the second one than the first one, right? In the first test, the burden is on the challenger, right? The burden is on the challenger. That is, I am a 16-year-old male, right? And I want to show why I can't get my license, right? I'm a 16-year-old and I want to show why I can't get my license. I have to show why this law is irrational. With rational-based review, the challenger has the burden to show the law is irrational. The burden is on the challenger to show the law is irrational. Let me tell you something. Showing a law is irrational is virtually impossible, right? Because you have to deal with every possible thing that might happen. This might happen, and that might happen, this might happen. You can't do it. It's going to be really hard. But with the higher levels, the burden is on the government to show the law is substantially justified, right? Okay. The burden is actually on the government to show that the law is substantially justified. Here, the government needs evidence to show why 16-year-old females get a license and 18-year-old males get it. Once you put the burden on the government, they usually lose. Not always, but usually. When you have the burden of proof in a case, you're probably going to lose. Because you have to show to the court's satisfaction the law is justified. Yep.
So for these burdens, is this the same thing as presumption of constitutionality and presumption of liberty?
Yeah. Yeah. The rational basis review, I can use that language, is often called presumption of liberty. I'm sorry, presumption of constitutionality, right? Where the court just presumes the law is valid. And with the higher one, you might have what's called the presumption of liberty, right? Where the court presumes that this law should not be in existence. All of this, my friend, stems from how you classify. Now, is it written anywhere in the Constitution that age discrimination is okay, but sex discrimination is kind of okay and race is bad? No. These are all judicially created constructs. We have one equal protection clause. In fact, Justice Stevens, one of his few positive contributions to law, of late at least, was that there's only one equal protection clause, and that they shouldn't have these tiers. I think I agree with him. These are all made up, right? These are all fictional. There's nothing in the Constitution which says that there are 3 tiers of review. This is made up. Yeah, Roberto.
In the first one, there's some states that are talking about putting government age.
Oh, I was going to ask about that. You stole my question. Yeah. So, actually, so funny story. My whole question was originally about guns. It's like, no, that's going to be too complicated. So I changed it to driver's license. So I was originally asked about guns. Yeah. So can the state tell someone who's 18 years old they can't purchase a firearm? I don't have time to go to the Second Amendment. I'll talk about the age aspect. There's currently a federal prohibition on handgun purchases for people who are under the age of 21. Handgun. And ironically, one of the justifications, well, you can't buy a handgun, but you can buy a long gun, right? You still have some means of defending yourself. Now, Florida is saying we're going to ban them altogether. There's a challenge pending in court. We'll see. We'll see what happens there. But I do think that if you have people who are 18 years old, the age majority, completely deprived of any means of self-defense, might have some Second Amendment problems. But they actually argue in their brief. This was crazy. They actually said that 18-year-old girls don't engage in mass shootings, so they should be allowed to buy guns. That if anything, females, it's almost backwards what I said before, right? Is that all the guys shooting up schools are men, so why are you challenging women the right to bear arms at this young age? Anyway, I'll leave it there. I think next semester I'm going to add back the Second Amendment. Maybe I'll take something out. I don't know what. Maybe I'm going to take out the probably the Nixon impeachment stuff. I'm tired of that. It's too much. I might do the Second Amendment next term. I have to pick and choose topics. It's always very difficult. But yeah, I don't have time. Okay. What else? All right. So we have. Let me scroll back down. So we have a rational basis, and there's a lot of stuff here. You have to go through your notes later and sort of piece through this. Maybe watch this part of the lecture again. But you have the rational basis review. You have this quasi-suspect for the intermediate scrutiny review. Now we'll do what's called strict scrutiny review. Okay. This standard was basically introduced in Korematsu. It wasn't called it, but if you remember in Korematsu, the government said, to have a racial classification, you need to have a really damn good reason, right? Like national security, right? Which is why they justified the internment of the Japanese Americans. So the test here is like this. The government policy, that is, I keep doing this thing, it switches tabs, I'm not sure why it's doing that. The means is narrowly tailored. Okay, there's your fit. To serve a compelling governmental interest. Those are your ends. Okay? The government policy, those are your means, is narrowly tailored. There's your fit. To serve a compelling governmental interest. So Sam, let's walk through this, right? First off, what's the difference between substantially related, it's the word substantially related, and narrowly tailored, Sam? What's the significance of that change?
To me, substantially related could be like a strong correlation, whereas narrowly tailored has to be like basically almost directly related.
Very good, very good. Okay? Narrowly tailored is, again, think of a suit, right? If you get a custom suit made, it fits you to precision, right? Every turn, every aspect of your body fits you perfectly. Substantially related is, a suit from like Macy's or something, right? Fits you okay, but it's not perfect. And the ration related is like, the burlap bag, you're just putting it over yourself and it kind of keeps you warm. When you're dealing with a racial classification, the government says you better have a damn good reason why you're classifying people on the basis of race, and this policy must be as narrow as possible. That is, you shouldn't use race more than necessary. Then you have the second language, right? Cindy, what's the difference between an important interest and a compelling interest? What's the difference between an important interest and a compelling interest?
So for important interest, it just needs to be essential for the state function.
Okay, and what's compelling?
Such as national security.
Yeah, so let's go back to Korematsu, right, for a minute. The government there said, we need to round up Japanese Americans and exclude them from the coast to promote national security. Right? This is to protect the homeland. Now, you remember I said, well, wait a minute, why did they have to round them up and exclude them? Why couldn't they do something more simple, right? Why couldn't they just say, all people of Japanese descent must take a loyalty oath, right? If you're of Japanese descent, take a loyalty oath. And if you pass it, we'll let you free. And if you refuse to take it or we're suspicious, we'll lock you up. Wouldn't that be more narrowly tailored use of race than just rounding up everyone and their children and their these little 5-year-old kids, right? What are they going to do? Right? So even though Korematsu was an application of the second part, right? They said this interest is compelling. They didn't really address the fit, right? They didn't ask, is this a justified fit? Or maybe they said that national security is so important, we don't even care about the fit, right? That it's so important that we don't want to demand the government to employ these loyalty oaths because that could, harm the homeland. Trey?
I think they said World War II actually passed strict scrutiny.
Oh, you did, and you read 2 of those cases, didn't you?
I guess yes, but I'm being more along the line when you have. Remember your credit this way. After 9/11, were there laws prior to that or that went into not trying to apply strict scrutiny to it and not have? I mean more on the internal internment type.
Well, so I don't have time to teach the Guantanamo cases, which I think what you're getting at. There's a question about whether people held in Guantanamo are subject to the 14th Amendment at all. But even so, they weren't held there because of their race. They were held there because they were picked up on the battlefield. The avenue of challenge for Guantanamo was what's called the writ of habeas corpus. Right? We may yet have one this term with the travel ban. This may come up about 2 months from now. So that might be an instance where they found a racial classification that was struck down, but they haven't found it quite yet. But let me focus on the Korematsu case just for another minute. The court there had no problem saying that national security was so compelling, but they didn't do the first half, right? Because it hadn't really been developed. They didn't go to saying, is this policy tailored sufficiently to justify the use of race? But then we go to a case like Brown. We go to a case like Loving, right? What was the government's reason why they had to ban interracial marriage? I told you. It said we need to protect children, right? We don't want to have children growing up in interracial families because they'll be stigmatized. Whatever, right? Is the state's interest in protecting children legitimate? Yeah. Is it important? Probably. Is it compelling? Not that much. You see the difference, right? You see the gradations, right? depending on how you define the interest, it's a different answer. Now, let's try it again. Is prohibiting intermarriage rationally related to protect the children? Probably, right? A ban on interracial marriage would probably survive a rational basis review, right? Is it substantially related? Probably not. Maybe yes, no, probably not. But is it narrowly tailored? That is the only way of protecting children from that stigma to ban people from getting married and throwing them in jail? Absolutely not. One second, Clint. What strict scrutiny is attempting to do is to what's called smoke out, right? Is to figure out this reason you're giving us is BS. The real reason you're giving this is actual racial animosity. And once you get there, you say, aha, the real reason is not for protecting kids, it's for promoting an aspect of white supremacy, and that the court says violates the Equal Protection Clause. And here again, the burden is on the government, right? And this is Trey's question, a burden that can't be satisfied. It's often said that strict scrutiny is strict in theory. Sorry, strict. Strict scrutiny is strict in theory, but fatal in fact. That is, once you get to a racial classification, you are going to lose, right? Once the court gets strict scrutiny, you're going to lose. Except for two cases, which you read today, where the court upheld the use of racial classifications. Grutter and Fisher. Right? Those are the two cases that I'm familiar with where racial classification was upheld while the court was purporting to apply strict scrutiny. So Clint was patiently waiting, and I think somewhere over there was a question also.
So, and I may misunderstand what you just did, but so you were talking about racial classification, yet you went through the racial classification. So, in applying the three-tiered scrutiny, do we do we classify it as a non-suspect classification first, and then go through that?
The exact order I gave it to you in. The exact order. First, you say, what's the classification? Race. What kind of classification? Suspect. There's your test.
Okay,
what are the means? What are the ends? And what's the fit?
Okay.
If it doesn't have the requisite fit, it's unconstitutional. The burden then is on the government to show why they need this law.
So what you just did was an example, not the way we should actually do it.
I think it's exactly how you should do it.
Well, because you tried to apply the first tier.
Oh, I see what you're saying. That was hypothetical, right?
Okay.
Yeah, you would never apply a rational basis review for a racial classification.
Okay.
I was trying to illustrate, if you would,
Perfect.
how the court would come out differently.
Okay, perfect. That was where the confusion
Thank you.
was.
Okay, I didn't make
Yeah,
that. Yeah, you would never apply a racial classification under the rational basis. You just wouldn't do it.
Okay.
But I want to see if you did, the law would probably survive.
Okay, perfect.
This is how, in Bakke v. Bell, this was JC's question, the sterilization plan. Now, that was a due process case. It was a little bit different, but the result's the same.
Okay, so we make the classification first.
Yes, sir.
Okay.
Thank you. Thanks for the clarification, Clint. Yeah, what?
So when we're talking about intermediate scrutiny and strict scrutiny, is there any validity to necessary and proper in our analysis?
Not really. It's similar, right, because of that deference, but I wouldn't try to compare the two. By the way, for a lot of you wrote on your midterm that Marbury v. Madison involved the necessary and proper clause. I couldn't imagine. I have no idea what that was. I was about 4 or 5 of you did that. That Marbury says necessary and proper. Maybe you confused McCulloch. I don't know, which was also not relevant. But that few of you wrote that was very strange. Yeah.
So under intermediate scrutiny, we've got the presumption of liberty that usually can't be overcome. Seems like strict scrutiny classified as a rule of liberty versus presumption.
It's not just presumption. It's almost like a, if you imagine intermediate scrutiny, you put a little thumb on the scale on the side of the freedom. With strict scrutiny, you put like a dumbwaiter. You just like drop an elephant on the scale, right? You're not going to win unless it's affirmative action. That's the only example. Yeah, McKinney?
So besides affirmative action, has anything else passed strict scrutiny?
I can't think of in the context of Equal protection with a racial classification, I think only strict scrutiny. And Korematsu, of course, right? That was an example 5 decades ago, right? But as a general matter, I'm only hesitating because the court has moved away from these tiers of scrutiny. So it's not a perfect answer, but 2 good examples are the Fisher case and the Grutter case, where they explicitly said these pass muster on strict scrutiny. Very good question. Thank you.
Thank you.
Chase?
You don't have to get too much into this, but when you mentioned like the bathrooms, how it kind of is one of those things, is that one of the ones that blurred kind of the line between the second and third tier? The way they
Yeah, so I mean, the issue of transgender discrimination is somewhat in flux. And I don't have time to get into today. We'll talk about the same-sex marriage decision next week or maybe the week after. It's an issue in flux, and every semester I teach this, my answer changes somewhat. We'll read a case next week called VMI, the United States versus Virginia. And Justice Ginsburg writes an opinion about whether you can have separate schools, a military academy for men and women. And she says, well, even though you need to have a single school, you can't have sex-segregated bathrooms. And she says that in her opinion. I don't know how long that's going to last for. Okay. Yeah, Kevin?
Is age, sex, and race the main
those are the biggies,
protected
yeah.
classes used?
There are others.
Okay.
For example, and I don't want to bog you down, but religion is often considered a suspect classification. Nationality is considered a suspect classification, right? Those are the biggies. Usually race, nationality, religion. Sex is here. Sexual orientation might be here. Gender identity to be determined. So these are issues in flux. And basically everything else, right? If it doesn't fit into number 2 or 3, it falls into number 1. And that's I won't even try and define all the various suspect, non-suspect classifications. I mean, for example, there's one, legitimacy. What? If your parents aren't married, the courts have held that that's a quasi-suspect classification. I mean, it doesn't come up ever, but there's some cases on it.
Where does mental illness fit?
Mental illness?
Yeah. So
we'll do a case called Cleburne versus Cleburne Living Center, which involves a mental home for people with mental handicaps. The court says it's rational basis, but doesn't really apply rational basis. I'm not showing you this now, but there actually exists something between 1 and 2, which used to be called heightened rational basis or rational basis with bite. These tiers break down real quick, my friends. I'm giving you the black letter, but they break down. And I don't think they matter anymore, but we at least understand the theory. You'll see why they don't matter once we get to Kennedy opinions. You haven't read any Justice Kennedy opinions yet? You're lucky, you're fortunate. You'll have to read them soon enough, and it just breaks all of your doctrine down. It'll drive you nuts. They make good Hallmark cards. They don't make good things for reading for class. Yeah,
So
Clinton?
it sounds like these aren't set, these are discussed.
Nope.
I mean, you can discuss these on the exam.
Yep.
Okay.
Yeah. Trust me, when you get to Kennedy, you'll say, what the hell, Black? This is so much easier. But you know, just enjoy the warmth now, and it'll get very cold. Winter's coming, as they say. I don't think it's Ken. He's a nice guy, but his opinions are very hard to teach because there's no doctrine. It's all fluidity and love and dignity and stuff. I mean, that's nice for reading, but doesn't help you on the exams. And if he retires, I can't wait to jettison all those cases. They won't matter anymore. It's true. It's an interesting point, though, right? I mean, after a justice retires, how long do his cases stay in the book? It's a really tough question. I mean, because once a justice is gone, his influence starts to decrease, and things fade out of the canon. They just aren't cited. So, I mean, Justice Brennan for 30 years was probably the most influential justice. I think I had maybe 2, maybe 3 Brennan opinions in the entire book. The Scalia opinions, I think, will be in there for a while, but the Stevens opinions, I think, are basically going to be faded out soon. The Kennedy opinions will be there for a while because they have to be, but their relevance, I think, will be diminished. Right? It's often said that if you want to argue for the Supreme, who is it? Erwin Chemerinsky, probably have his book, says, you know, if I could write a brief to the Supreme Court and put Kennedy's face in the cover, I would. Right? People always try to appeal to him because they know he's the only vote that matters. It's very unfortunate. No one person should have all that power. All right. To the great philosopher Kanye. Yeah. Yeah, go. Sorry.
How about Ginsburg? Do you think she's going to have legacy?
I have maybe 2 Ginsburg opinions in the entire book. It's not her fault. She was usually in dissent, and dissents usually don't have that much gravity. But I think I have, I mean, you can check the index, maybe 2 or 3 Ginsburg opinions.
But you can have a legacy as a dissenter, right? And that could be, you will be like mindset is like very.
Who remembers them? I mean, Scalia would always say this, right? He would always say, "I make my dissents so angry to get into case books." Right? He says, "I want law students to read my dissents because they're fun to read, and they work." Right? And they'll be there, I think, for some time. But even now, the book, Ginsburg just has a handful of opinions. I don't think I have any Kagan opinions yet. Maybe one. But it's a hard decision what to include, what to exclude. All right. Any questions on this framework? All right. So go back. This is basically an hour to explain this. I know how long it would take. We haven't done a single case yet. Don't worry, we'll have time. But these three aspects will come up over and over again. You need to understand it to then understand how the court doesn't apply them, right? It's easy enough for me to sit up here and read these to you, and then say, and the court just ignores them, and which is generally what happens. They're more useful for the lower courts, right? The lower courts do try to adhere to these faithfully. I don't know about the Fifth Circuit and Fisher, but they do try to adhere to these faithfully, but they're just not followed at the Supreme Court. All right, any questions for Warren?
Are these primarily used in equal protection?
Yeah, so I'm going to have to make you even more angry. They're used in the context of equal protection. They're also used in due process, right? With due process, it's a little bit easier. And let me give this to you back to back so you have it. I don't know if I maybe didn't make it so clear, but right? All this is for equal protection, right? These are the tiers of scrutiny for equal protection, right? Let's talk about due process, tiers of scrutiny. We'll get to this when we do the gay marriage cases and Lawrence, but I'll give you a preview now. A little bit easier. You have what are called non-fundamental and you have fundamental rights. Okay? You have non-fundamental rights and you have fundamental rights. Fundamental rights are given what's called strict scrutiny. That's how I spell it, strict scrutiny. And non-fundamental rights are given what's called a rational basis scrutiny. Okay? All right, wow, I'm not spelling today. Scrutiny. Okay? There's no middle of the road tier, at least in theory. Okay? Certain rights which are deemed fundamental are given very strict scrutiny. And other rights that are deemed non-fundamental are given what's called rational basis scrutiny. So you ask, Josh, wait a minute. What's the difference between a fundamental right and a non-fundamental right? Short answer is whatever the court says. Caroline Products, footnote 4, said that there are certain types of rights protected and certain rights are not protected. Things in the Bill of Rights are fundamental. They're listed. Things not in the Bill of Rights are not. But what about unenumerated rights? A right to contraception, a right to abortion, a right to assisted suicide, a right to same-sex sodomy, a right to same-sex marriage. Go down the list. Are these rights fundamental or not? We'll get there, but I want to give you a little preview, Warren. Right? The short answer is if you're dealing with a fundamental right, it's given a strict scrutiny. Otherwise, it's not. Now let me give you something else. There's a third test. Abortion has what's called the undue burden standard. You guys are going to hate this, right? What happens is they make this test and they carve out exceptions. So abortion is a world unto itself. It has a test called the undue burden standard. I'm not even going to explain to you what that means now. And it gets worse. For the First Amendment, there's also tiers of scrutiny. I'm not going to give it to you now on the board. But depending what kind of speech is at issue, it can be rational, intermediate, or strict scrutiny. They mean different things. There are different tests for different kinds of speech. So the court makes these convoluted tests for every kind of right and carves out exceptions to them which don't apply consistently, forcing you all to learn these various tests that don't really matter. Right? But you have to ask Warren. For due process, we'll get there next week. There are various tests for different kinds of rights and different scrutinies. You're welcome. You asked, I answer. Right? That's what I paid to do. Something like that. All right, any other questions on that? All right, let's move to affirmative action. And we can do these cases actually somewhat combined because they all address basically the same issue, just in different decades. Should which is more or less how I think of them. That's what we got. So actually, this is a picture of Alan Bakke. I think you have a picture of him in your book as well, who eventually did graduate from UC Davis Medical School after the court ruled in his favor. All right, so you might be asking, Josh, why are you still assigning me this case in the 1970s if we've had these other decisions, the Michigan case and the Texas case, which have some supplanted it? I don't know. I would take it out, but my co-author wants to leave in, so I'll defer to his judgment. But at a minimum, Justice Powell's opinion in Bakke provides the basis for how to think about the use of race-based preferences. So let me start off the discussion like this. Everyone agrees that a racial classification designed to hurt people is unconstitutional. Think of Brown, right? Segregating schools. Think of Loving, right? A criminal prohibition on interracial marriage. I think everyone would agree those are bad. But what about when race is used with a design to help people? Here the answer splits significantly. There's not the same kind of consensus on Brown and Loving as there is on Bakke, Grutter, Gratz, Fisher, right? There's it's almost a 5-4, it always seems to be. Okay? Why? It goes to the nature of what affirmative action is. And you've all heard the phrase affirmative action, and probably until you did your reading, you know what the phrase actually meant, right? There are a couple different ways to deal with racial discrimination. One is to say, we will not discriminate. Okay, that's one way. The other way is what President Kennedy called take affirmative action. That is, you have to take steps, positive steps as affirmative action to ensure that employees are not discriminated against. Throughout the 1960s and 70s, this often took the form of what's called a quota, right? A quota. And it's an important concept. This headline from Time Magazine describes the Bakke decision in like 2 pictures, right? Bakke held that quotas were not permitted. That is, set aside X number of seats for African American applicants, Y number of seats for Hispanic applicants. Justice Powell said that that's not permissible. But could race be considered in the process? Powell said yes. Okay. Now, why? Right? That's the important question. Why was Justice Powell in Bakke not willing to accept a quota system, but he was willing to accept race being used as part of the analysis, as a factor?
So he factors in the...
He factors, that's good.
I didn't even realize I was doing that, to be honest. He factors in the scrutiny and says that to say race by itself is a determinative factor in an application would not pass strict scrutiny. But it could be, if it was only a factor that wasn't determinative, then it would be, I guess, narrow enough to fit within that.
There it is, right? Right. So, Janelle, let's talk about this in terms of our scrutiny test, right? So, the government policy, they have 2 different options, right? You can have a straight-up quota set aside, or you can have some sort of racial diversity policy, right? Describe for me the difference between the fits between the quota and a diversity rationale. What are the differences in the fit?
I feel like the fit of a quota isn't as compelling as it just being a factor.
Well, we didn't get to compelling yet. That's actually the second question. Let's just stick with the fit for a minute, right? Why is a diversity policy more tailored than is a straight-up quota?
Why is the diversity policy?
That's my question.
It's going to depend on how many people they actually admit, I guess. Like you'd be able to put
put that under a microscope instead of, you'd have to put it under a microscope to make it work.
Well, okay, let's start with you. Alexandra, let me ask you this question, right? What is the compelling governmental interest, according to Justice Powell, that's permissible, right? What is the interest that's being served?
Was it to remedy past discrimination?
No, it was not. And that's an important point. That's what everyone wants to say, right? Everyone wants to say that the compelling interest being served was to remedy centuries, right? Centuries, not even decades, centuries of racial discrimination. Centuries.
Sorry, diversity?
Well, not just diversity for its own sake. What of diversity? Why is diversity important according to Powell? This is why his opinion's on the book, by the way. This one question. So I would cut it. David, what is the compelling interest here that's permissible according to Justice Powell's opinion?
Promotes.
Not just diversity. You got to get a little bit more than that. Gabe?
Educational benefits.
Bingo. Say it again.
Educational benefits from diversity.
Yes, sir. Okay. It's not just diversity by itself, because that's merely balancing. That's having X number of white people and X number of black people. That's a quota, right? Merely saying diversity, having X of this race and Y of that race, that's a straight up quota. It's the benefits to education that come from having a diverse class, right? People get this wrong in the exam every year, right? It's not just diversity. You have to be very careful about that. Because if it's just diversity, that's a quota. It's the benefits, the educational benefits that result from having a diverse class, right? That's your compelling interest that Powell finds. The educational benefits that flow from having a diverse class. Now, David, let me ask you this question this way then, right? If your goal, if your interest is educational diversity, why is a race as a +1 factor permissible, but race as a strict numerical factor not permitted, right? Why is one better served than the other?
Because you're giving one classification of race more opportunity, or you're limiting, their class. It's not equal.
Well, let me ask you this question differently, David. Does merely knowing a person's race tell you how they'll benefit a classroom? Ah. But what could tell you what kind of benefits they'll provide in the classroom? Ah, okay. So the reason why Justice Powell accepts racial classification here is because the quota doesn't get you the benefits you need. But race as a factor, like the Harvard plan, which we discussed, can let an admissions officer know, okay, will this person provide benefits to the class, right? Everyone get that point, right? People don't get this. They think, oh yeah, diversity. It's not just diversity. It's part of diversity with respect to the benefits of the classroom. Okay. Yeah, Andrew.
Can you elaborate what Justice Powell means?
I wish I could. O'Connor will. He doesn't really explain it. And if you read the opinion, you are sure you're not alone. For the 25 years between Bakke and Grutter, no one knew what Justice Powell meant. And in fact, in the years after Bakke, the Fifth Circuit, right here in Houston, issued a decision called Hopwood, in which they invalidated the University of Texas's affirmative action policy. And they thought that was consistent with Bakke. So it wasn't until the Michigan case that tells us what the hell Powell meant. One other point on Powell, this wasn't a majority opinion. This was a concurring opinion, right? And this is a weird case where there was no majority. 5 justices agreed, right? 5 justices agreed that the University of California's policy was unconstitutional. They didn't agree on a rationale. 4 justices said it violated a statute. Powell said it was unconstitutional. Then you had 4 other justices who said, no, it's fine. So what the hell is the majority opinion? For decades, people said, well, it's Powell's opinion that was controlling, but no one really knew. It wasn't until O'Connor then adopted Powell in the Michigan case that that issue became resolved. Right? So everyone with me so far? Is the Justice Marshall dissent still in your book? I can't remember if we left it in. No, we took it out. Yeah, this is my slowly nudging Randy to move the case altogether. I prevailed upon at least it. Yeah, Kevin?
So when we say quota, is that basically saying like
Numerical.
diversity for the sake of diversity?
Yes, it's what Justice Thomas would call racial balancing, having X number of white people, X number of black people, fixed numbers. So the upshot from Bakke, and this part is not disputed, is that racial quotas were not permissible. That much was easy. What was the variable is that can you have race as one of many factors? And that was an open question until the Michigan case. All right, Michigan was a 5-4 decision. It could have come the other way just the same. The Marshall opinion, which, again, I would take this case out entirely, but the Marshall opinion I think is the most honest in the entire bunch. He says, let me read you an excerpt. During most of the past 200 years, the Constitution, as interpreted by this court, did not prohibit the most ingenious and pervasive forms of discrimination against the Negro. Now, when the state acts to remedy the effects of the legacy of discrimination, I cannot believe that this same Constitution stands as a barrier. What Justice Marshall is saying, I think this was Alex's point a few minutes ago, is the reason why we have affirmative action is to remedy centuries of racial discrimination. And this diversity rationale is basically BS, right? That's not the real reason. If you were to put most college admission officers under a lie detector test, like a polygraph, they'll admit Marshall's right. And this is Ginsburg's point in her dissent in Fisher, that all this up at diversity is, it sounds good in court, but the reason why these policies exist, in particular for African Americans, is because of this long legacy of discrimination. But the Marshall rationale never gained a majority of the court to this day. Justice Kennedy didn't adopt this in Fisher either. It's still about the benefits from diversity. So that's your rule, right? The compelling interest to uphold affirmative action is the benefits from diversity. So we now have, and this was McKinney's question a couple minutes ago, what are the two compelling interests that allow a racial classification to survive strict scrutiny? National security in Korematsu, and number two, benefits from diversity in affirmative action. Are they on the same scale? I'll let you guys decide that. But you can see, especially when you get to Fisher, is the court actually applying strict scrutiny, right? Are they using a microscope? Are they using a magnifying glass? Right? Are they using those little 3D glasses you get to the movie theater? Right? What are they using to look at these things? Okay. Any questions about Bakke before I move on to the Michigan case? Yeah. What?
After the holding in Bakke, was there ever anyone who tried to challenge Kennedy's executive order under his power, I guess, to issue that? I know
President Kennedy. Oh, not Justice Kennedy. Yeah, President Kennedy. Yeah. God help us. If Anthony Kennedy could issue executive orders, we're done. Those opinions are basically executive orders. They're the force of law because he wrote them. I don't know, actually. I don't know if anyone ever challenged the President Kennedy executive order. I don't know the answer to that question. I suspect the answer is not. There were some other cases which we don't have time to cover, which involve challenges to quotas. I don't know if anyone challenged the Kennedy order. I'm not sure. Okay, any questions on the Bakke case? Important case only because no one knew what the actual holding was until O'Connor 20 years later.
Yeah, I feel like when they settled this case, they were trying to find a common ground. So because it wasn't so clear, to some degree, the universities tried to interpret their own style, what Powell said, and then as we saw decades later, some of the methods that were using, it wasn't they were using diversity as what he said, but it just wasn't so clear.
Right. And I think Gabe raises a fair point, right? There was not common ground in the Supreme Court at all. And Powell says, well, you can't do this. You can't do quotas, but you can do the Harvard plan, right? And a lot of schools have emulated the Harvard plan because at least one justice said that was okay. But it created a lot of confusion. And this actually led to the Hopwood case, which I mentioned earlier. where in the, I think it was about 94, 95, the Fifth Circuit basically struck down the UT Austin's affirmative action policy. And this led to the creation of what was then known as the top 10% plan. And I'm sure most of you Texas, you know what this is, that if you finish in the top, it's not always 10%, the number fluctuates. But if you finish in the top X percent of your high school class at a public school, you are guaranteed admission to the school of your choice, which can include UT Austin or A&M or Tech, wherever you want to go. Why was this policy adopted, right? Well, the people who drafted this weren't idiots, right? They recognize that Texas schools are basically de facto segregated. What does that mean, right? There's no policy saying black kids go to this school and white kids go to this school. That policy doesn't exist. But if you look at geography and where demographics people live, you have a lot of schools that are predominantly Hispanic. And you have a lot of schools that are predominantly African American. And if you take the top 10% of a given school in such a neighborhood, you're going to be pretty sure they'll be predominantly of a certain race, right? That's going to be numerically. That policy was designed to get UT the numbers they wanted of minority applicants. It didn't do enough, though. And in the period between when Hopwood was decided and then Fisher, Hopwood and the Michigan case, UT said they weren't able to achieve the benefits and diversity they wished. They weren't able to achieve this number called the critical mass. And this is a number that comes up, this critical mass of a certain number of people. Now, UT would never define what that number was. They refused to. They said, well, we'll know when we see it, so to speak, right? We know when we'll get there. But the fact is that this number exists. Is that a quota, right? Is whatever that number is a quota? And the lawyer for UT, if you want to see a good lawyer dance around a question, you dance around that question very well. It would not be pinned down. But that's an important issue. All right, yeah, Ken.
So with the 10% thing, were they even close to the...
They were very nebulous. The UT, part of the problem with this case, I'm skipping ahead a little bit, part of the problem is that they were very nebulous what they were looking for. And then the questions went of deference, right? Do we defer to the school's determination of what a requisite critical mass is, or does the court decide for itself? Let's do Grutter first. Who's next? Ronnie, I think you're next, yeah. So, describe for me the difference between the admission policies of the University of Michigan Law School and the University of Michigan undergraduate. What was the difference between the two admission policies, please? Well, describe the undergraduate policy first, and then describe me the law school policy, please.
I think the undergraduate one looked at factors such as high school grades, standardized tests, quality, curriculum, relationships and leadership, and in the other one it looked at other factors such as.
Well, did both undergraduate and law school look at race?
Yes.
Okay, so what was a different manner in which the undergraduate and law school used race? That's my question. Damon?
From what I remember, in the law school admission, they would give a certain percentage of admission to the race classifications.
Yeah.
I think it's that the law school race was a substantial factor, and in the undergrad they awarded 20 points.
There it is. Yeah. Right. So there was a difference between the law school and the undergraduate, right? The undergraduate would award points straight up based on your race. That is, if you were, African American or Hispanic, you would get points, and you would need a certain number of points for admission. And in some of these cases, right, like having a 1600 on your SAT, it was basically worth less than being of a certain racial classification. The law school, though, wasn't so obvious, right? They probably achieved a similar result, but in a smarter fashion. They said, well, we'll look at race as one of many factors, right? Race will be part of the application, but there's not a numerical value, right? The key distinction is that being of a certain race was a numerical plus, right? If you were a certain race, you got X number of points added to your score on the undergraduate, whereas in the law school, there's not a straight up numerical value. It was what they called holistic. Holistic. Kevin, what does that word mean, holistic?
Well, I mean, they talk about like referencing like soft variables in the overall general applicant. So they don't just look at what's, like, I guess, what your bottom line scores were. They look at how your scores related to, like, they said that, like, enthusiasm and quality of your undergraduate institution, or like the quality of your background.
Kevin, just one more, I'll let you go. What does the word holistic mean? Just the word by itself.
Just a general overview.
Okay, you want to try? I said holistic. What does that word mean?
Something that is connected with something else.
Okay. Amber, want to try another step? Holistic.
Yeah, it means to like take a bunch of component parts.
Yeah.
that
Okay.
are interconnected.
Yeah.
And then view it as a
Yeah.
whole.
Yeah. I think that's closer. I'm looking for, right? The court says, and this is how Michigan defended it. Their policy is holistic, right? Every student is reviewed in an individualized fashion. And you consider all of the ways that an applicant might contribute to a diverse educational environment. Okay? Race is described as what's called a plus factor. A plus factor that's flexible enough to ensure that everyone is evaluated as an individual, and that race is not the defining feature of his application. That's the important point. Race is one of many factors to be considered. There is no mechanical, predetermined diversity bonus, the court says. Okay? There's no mechanical bonus. So whereas having, checked off the African American box might be worth more than a perfect SAT for the undergraduate, for the law school, it doesn't overwhelm. Now, the difficult question, though, how exactly does holistic review work? Right? This is where the case breaks down very, very, very quickly. The school doesn't really tell. They provide some guidance, but their bottom line is trust us. Right? Trust us. This comes out much more in the Fisher litigation than the Grutter litigation, but basically you need to defer to expert educational institutions to decide the best way to conduct this sort of holistic review. And I mean, in fairness, to defend them, if every review is individualized, how can they describe as a general matter what they do? Right? What we don't know, though, is exactly what factor or how much race weighs in. But Justice O'Connor votes to provide the deciding vote to uphold the law school policy, and then she votes to strike down the undergraduate policy. And she does this based on Justice Powell's concurring opinion in Bakke from 25 years earlier, where she says, well, the undergraduate, it's kind of like the quota, it's numerical, it's rigid, it's mechanical, that's not going to work. But the law school is like the Harvard plan, it's flexible, that will be permissible. Everyone with me? Okay. That's the O'Connor opinion. I think. Any questions on the O'Connor opinion? Juliana, O'Connor ends her opinion with this very funny, funny is the wrong word, this sort of very strange a line where she says, we've been 25 years from Bakke to Grutter. And she says, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. So this was in 2018, we're now at 2018, right? 2018, so about another 10 years. Do you think she was actually being serious there? The holding of Grutter is that in 2028 we can stop using affirmative action. Is that the holding of Grutter? No, why are you saying no? Yeah, I think you're right. Why are you saying no? Yeah. Yeah. This actually came from a picture where Justice Scalia was being a smartass, as he often was, and he asked the lawyer, I have the quote from the transcript, by the way, do you think that affirmative action will be needed in 2028? Was that the holding of Grutter? And then the lawyer says, we don't read Grutter as establishing that kind of clock. But you're appealing to Grutter, that's what it said. So he's still mocking O'Connor a decade later. But I think Joanne, I think you're right. O'Connor wasn't serious. I think he was making a rhetorical point. But it does raise the question: at some point, right? Does this fit become less strong, right? Perhaps in the year 1978, you needed a more robust affirmative action policy, and then in 2003, you needed perhaps a less robust policy. And then 2020, maybe even a less robust policy. So can it be that a policy that passes muster in 2003 might not pass muster in 2028? Could that be? Well, I don't take O'Connor seriously, so I think that's probably no. But Fisher, I think, goes a long way to solidifying the permanent repose, as it were, of the dissents. So any questions on the majority opinion? In either Grutter or Gratz? Grutter is the law school one, Gratz is the undergraduate one. I have pictures of them both. This is Barbara Grutter, who was the lead plaintiff in the law school case, and this is Jennifer Gratz, who was the lead plaintiff in the undergraduate case. And I actually have pictures, if you want, of the University of Michigan undergraduate admissions office. Not that you care, but I have them. Okay, let's do the dissents. Actually, what is Justice? What's Justice Thomas's dissent in the Grutter case?
So Justice Thomas, he believes kind of, that African Americans don't really need this in order to achieve, I guess, their means that, kind of, he goes along the lines of what Frederick Douglass said.
Yeah.
Kind of, like, stay out of our business and stay out of our way.
Mm-hmm.
So
Yeah, and there's some beef here, right? There's some history here. I encourage you, if you have time, to read Justice Thomas's autobiography called My Grandfather's Son, a very good book, very accessible, very readable. And he tells the story of how he was admitted to the Yale Law School in the 1970s under the school's affirmative action policy. And he resented that for years because he thought it made the value of his degree less. In fact, he basically took his diploma and he put like a cigar sticker on it. That's how much he cared about it. He said it was worth 25 cents, whatever the sticker was for the cigar. And for years, he would not hire law clerks from Yale because he had so much bitterness towards the institution. He ultimately came around and started hiring Yaleys, but hasn't changed his opinion on affirmative action. And I like to juxtapose Justice Marshall, who was the first African-American in the court, with Justice Thomas, who was the second, who replaced him, as it were. And they have just wildly different perspectives on race. Justice Marshall said, these people have been discriminated against and hobbled for centuries. The Constitution should not stand as a barrier. And Thomas says, if we can't stand up our own 2 feet, they should let us fall. And he has a bust of Frederick Douglass sitting in his chambers. So these are very differing perspectives of Constitution. And he basically says the Constitution means the same thing today as it means in 25 years, and we should overturn Grutter immediately. He also makes another point that I want to stress for a minute. He says that what exactly is a state's compelling interest here? Does the state have a compelling interest in having a law school? Right? Does the state have a compelling interest in having an elite law school? If the state was interested in admitting more people of different racial backgrounds, they could adjust the admission criteria, right? They can make their LSAT scores perhaps different. They could perhaps not require the LSAT. Some schools don't even require it. That if they were actually trying to achieve this diversity, they could do it without using these racial preferences. He cites historically black colleges. But his point is saying is they don't want just a law school. They want a top 15 law school. They want an elite law school. And that cannot be a compelling interest. And he has this one note, which I always chuckle at, that most UM graduates leave the state, right? They don't even stick around after they graduate. So they're not even helping the state government. So what Thomas's point is we have this strict scrutiny test, right? It's not being applied. we don't have narrow tailoring, and we don't have a compelling interest. So he says this is a poor application of the strict scrutiny standard, and that this is basically just about cosmetics and making people have a certain appearance, but not actually serving the interests well. Any questions on the Justice Thomas dissent in Grutter? Any questions on the Thomas dissent in Grutter?
How would you sum up?
Oh, you want to raise your hand, please? Thank you.
How would you sum up Thomas's dissent? Would you say that using race to admit students is unfair to the minority?
He thinks that, yeah, I think Thomas would say that admitting a student based on their race devalues their education because people think that they were not admitted for their merit but based on some other factors.
Thank you.
Any other questions on the Thomas dissent? Let's do the Ginsburg dissent in Gratz. Again, Gratz was the undergraduate program. And Justice Ginsburg makes, I think, was a very astute point. I was in college when these cases were being decided. And I remember professors talking about this. I think I actually asked my professors, I said, if the courts rule, I went to Penn State, a state college, a state institution. I said, if the court rules against affirmative action, what are you going to do? And I can't remember exactly what she said, but she basically said, we're going to do the same thing we're always going to do, we'll just label it differently, right? And this is Ginsburg's dissent. She says, look, no matter what the court says, the schools will still keep doing their mission, right? They're going to call it something else. And Ginsburg says, if we have a choice between honesty and, covering it up, I prefer honesty. And they candidly disclose those numbers instead of concealing it. Okay. Questions on the Ginsburg dissent or the Thomas dissent or anything else in Grutter or Gratz?
What about requests? Why did they ever address the disparity between other races at all? That they didn't rise as well?
What do you think?
No, I'm serious. I'm curious about that still to this day. Because if you look at applications, they have all these categories that aren't always applicable to everybody.
Yeah, I mean, this comes up a little bit more in the Fisher case, but not all racial minorities are viewed the same way for purposes of these admission programs. And there's a footnote in the Alito opinion about Asian Americans, which makes it point a little bit more bluntly. I think that Michigan's policy only makes sense if you look at Justice Marshall's opinion, that this is about specifically making up for centuries of racial oppression against African Americans. And that doesn't apply, perhaps to the same extent, to other groups. But then we have internment. We have lots of other people who have legitimate histories of grievances. Steph, I'll get to in a second. But there's not a thorough vetting of this in the majority opinion. The majority opinion is willing to defer to the educational institution. Stephanie.
I wanted to see if we could talk about Ginsburg's dissent.
Sure.
She made the distinction between policies of inclusion and policies.
Yeah, good. Yeah.
You want to take it from here?
What do you know? You tell me. You wrote up. I'd be happy to talk about that. By all means.
I mean, I can understand how both types of policies can frustrate the equal protection clause, but I mean, I don't see how you can't look at it in a historical context because, I mean, when you're trying to balance something, there's always going to be like something's being taken away from them. Mm-hmm. So, should policies of inclusion be more easily justified?
Good question. I was going to bring this up with the Thomas dissent in Fisher, but I'll do it now. So Stephanie raises a fair question, right? Is there a difference between using race to help versus using race to hurt? Is there a difference between using race to include versus using race to exclude? So let me answer the question in two different ways, right? If you're Jennifer Gratz, was Michigan's policy a policy of inclusion or exclusion? She was denied entry to the university.
Yes.
This is like the wolf and the shepherd, right, and the sheep. It's the same thing, right? If you ask, Barbara Grutter, what a 160 something LSAT, right, 3-point-something GPA, 3.6 GPA, good grades. Was Michigan's policy one of inclusion or exclusion?
Neither.
Oh, she said it was exclusion.
Yeah.
You may not agree, but the same policy, go back to Alan Bakke, right? Right? He was denied entry and someone else was admitted. Would Alan Bakke say it's a policy of inclusion or exclusion?
You would say it's exclusion
Yeah.
because he doesn't have the same opportunity.
Yeah, exactly. So the question here is this. I think Stephanie puts it in a good way. One person's inclusion is another person's exclusion. But should we care about Alan Bakke's exclusion? Should we care about Barbara Grutter's exclusion or Jennifer Gratz's exclusion? Right? Ginsburg is basically hinting at saying, you guys have enough stuff, don't worry about it, right? This is Marshall. I always mention the Justice Marshall opinion, saying, look, we've had 200 years of racial segregation. Get over it. There was actually this one quote, which I don't want to put in the book because it's not verified, but apparently Justice Morrow said this at a conference. And I found this in Justice Douglas's autobiography. There was some case about racial preferences. And I want to get you the exact quote. He said this at a private conference, but Justice Marshall once said, "You guys have been practicing discrimination for years. Now it's our turn." Again, I won't put this in the book because I don't know if it's true, but Justice Douglas put it in his biography. He was nuts, Douglas, so I'm somewhat hesitant. I don't trust him. But the sentiment, though, carries, right? Is discrimination to support people who have been historically oppressed justified? And this is the Thomas opinion, right? Thomas says there's no difference between keeping Linda Brown out of Sumner Elementary and keeping Jennifer Gratz out of Michigan and keeping Abby Fisher out of UT. And Ginsburg's like, what are you guys, nuts? Right? Of course there's a difference. One's born out of trying to help racial minorities, the other one's born out of oppression, right? There's not a middle ground on this one, right? The justices, Thomas and then Ginsburg, you mentioned, they are on opposite sides. You want to add something? I took over your question. I apologize.
No, that was it.
Yes, Clinton.
So on the Time cover magazine, do you know who the...
I have no idea. I was actually thinking that. I have no idea who that is. Okay. If you want to look it up, maybe this...
I tried to look it up, and I have no clue.
I've actually... Yeah, I have no idea, actually. Maybe I should do some homework. Evan, yeah, go for it.
My question is just about the Bakke case. So they ended up ruling against Bakke, but then Bakke got into...
No, they ruled for Bakke. There were 5 justices who said that the Davis policy was unconstitutional.
Okay.
Yeah.
Okay, so then he got in.
Yeah. Are there questions in the Michigan case before we go on to the Texas case? All right.
Way out of the Ginsburg Dissent with respect to the number of applications, like so something that like that because I mean you had this like mechanical overview of things. I was just trying to relate that to
Yeah, I think the Ginsburg opinion is basically trying to resurrect the, not quite Powell, but the quota somewhat that you can have mechanical. Because think about it, if you have thousands of people applying to university, to do an individualized assessment for 1,000 people is a lot of work. She would, I think, defer to how the university wants to structure it with undergraduate policy. Okay? So let's do the Fisher case, right? Now, there's a big difference between Michigan and Texas, right? There are a lot of differences, right? They lost in the Final Four, but we'll put that aside for now, right? No blue. So the state of Michigan doesn't really have a history of slavery. They don't. They don't have a history of racial discrimination to the same extent as does Texas. Is there a difference then when Texas tries to remedy discrimination versus Michigan? This came up during litigation. So, for you next, you want to give us the facts in Fisher, please? It's basically the exact same case, just with a different plaintiff.
So Fisher was applied to the University of Texas as a constitutional clause, which makes sure so high school students who rise in the top 10 of their class are admitted automatically to any public schools in Texas.
Mm-hmm.
And she was not in the top 10 in her class, and so she filed suit against the school and claimed that it violated equal protection.
Okay, very good. Ava, So you went to school with Abby?
I did.
Yeah. Yeah, I had a student a couple years ago who was in her class. She went to Sugarland High School. Can I ask you, how hard was it to be in the top 10% of Sugarland High School? Was it really tough?
Yeah, it actually really was. I remember that you had to have, I think, like 4.2 or something.
And how's that compared to other schools? I didn't go to school in Texas.
Like Downer Street is another school, kind of not very good, and a lot of people were trying to transfer there. You had to have like.
Is that I've heard that? Is that a thing? Transferring your senior year to get into the 10%? Is that a thing? I've heard that. People have told me they've done that for their kids. So Abby did not make it in the top 10%. She went to LSU, as it turns out. She was not very happy there. I'll leave it there. But she apparently wasn't very popular. We'll leave that there either. But there was actually a second plaintiff. I don't remember her name, but also was a plaintiff challenging the UT's policy. She went on to law school at SMU, so she withdrew from the case. I don't think she wanted to be the name of a case as it was going to the Supreme Court when she was in law school. It's probably a prudent decision, but Abby stuck around. So there were two versions of this case. There were two renditions of this case. It came back twice. Who's next? So what happened the first go round? Right. Let's talk about the Fisher 1 and Fisher 2. Right. The Fisher 1 and Fisher 2. What happened the first go round?
So in the first case in 2013, the appellate court in Texas basically used a good faith standard, and the Supreme Court rejected that standard.
Very good. Let me stop you. Something very good. You said that the Fifth Circuit, right? That's the appellate court in Texas, applied a good faith standard. What do you mean by that?
Good faith as in
What?
basically giving more deference, more leeway.
Well, let me ask you this question, right? So Texas had the top 10% plan, right? Is that being challenged here?
No.
What was Abby Fisher challenging?
So she's challenging the fact that UT considered race in its acceptance.
Okay, very good. Thank you. So I went here. So she wasn't challenging the top 10% policy, right? She was challenging the actual affirmative action policy employed by UT Austin, right? Now, UT said, look, we're doing the same thing that Michigan did, right? The law school. We are just using race as one of many factors. Fisher was not seeking to overturn Grutter. What? Yeah?
Should they have considered challenging the top 10% thing?
Well, I'm going to answer your question differently. They weren't trying to overrule Grutter, right? During the arguments in the first go-round, I think it was Scalia asked, are you trying to overrule Grutter? And they said no. So they more or less accepted Grutter as a given. They were trying to say that the UT policy was not consistent with Grutter, that too much of an emphasis was placed on race. Now, I think Amina said something correct. She said that the lower court, the Fifth Circuit, applied a good faith standard, right? What does that mean? What's going on? Is that noise? Is that me? Whoa, I'm hearing myself. That's actually a little trippy. Is that my live stream? Is that what that is?
Yeah.
Oh, yeah. Oh God, it's like Inception level 5, right? I don't know what's going on, right? I'm teaching myself. So the Fifth Circuit employed what they call a good faith standard, where they basically deferred and they said, well, even though we're applying strict scrutiny, we're going to defer to the institution to decide how best to structure their policy. That is, we're not going to second guess their policy. Wait.
Doesn't that completely undermine the whole policy behind strict scrutiny to say that, like, we're going to apply this super, investigative standard to make sure nothing's going wrong, but, like, you got it, and we're not going to say anything about it because you're an expert.
Right, so that's my question for Arlene, right? Did the court in Fisher 1, I'm talking Fisher 1, not Fisher 2, let's talk Fisher 1 for a minute. Did the court in Fisher 1 think that the Fifth Circuit applied strict scrutiny?
No, it didn't.
Okay, tell me why.
Because the Fifth Court gave its reasoning and they gave a degree of difference to UT. They didn't, I guess they didn't ask them about whether it was a tailored fit, if it
Okay, very good. So in Fisher 1, right, again, in Fisher 1, the court said, we do not believe that the Fifth Circuit applied strict scrutiny, right? That they didn't see whether that they used narrowly tailored means, right? Perhaps the top 10% plan was enough by itself, right? They said that we're not challenging whether compelling interest exists. We're not overruling Grutter. We're still saying that the benefits from diversity are compelling interest. What they did say is that the Fifth Circuit failed to properly show narrow tailoring, right? They didn't use the microscope. They used the magnifying glass. Or maybe they used no glass at all. Okay? Now, there's a little note in your book about what happened in the Fisher case. And this is what we call in the business inside baseball, right? Inside baseball. And none of this is, gospel. We don't know if this actually happened. But apparently, when this case was first argued, there were 5 votes to strike down the University of Texas's policy. If you'll recall, Justice Kennedy dissented in Grutter, right? Kennedy dissented in Grutter. He was not in the majority. O'Connor was the majority. She's off the court. O'Connor was replaced by Justice Alito, who was very hostile to affirmative action. But as the story goes, apparently Justice Sotomayor circulated a dissent. A dissent that was apparently very strong. And Justice Kennedy said, well, we can reverse the Fifth Circuit and hope they clean up our mess. Right? So what they did is that let's reverse. Let's say, okay, Fifth Circuit, go apply strict scrutiny. And they were hoping, fingers crossed, that the Fifth Circuit strikes down the policy and they can just deny review. Nope. Fifth Circuit called their bluff. It went back down to the Fifth Circuit, and they did the exact same thing. They basically ignored Fisher 1, right? And if you want, go read the Fifth Circuit's decision. They basically did the same thing they did before. They made no difference, right? They applied the same level of deference. Goes back up in Fisher 2. Once again, Kagan was recused because she had advised in this when she was at the DOJ as the Solicitor General. So you're down to 8 justices. So, a best case scenario is you get a tie. So the case was argued in 2016. Is argued in 2015. November or October. And I listened to the arguments. I had students ask me about that day. It looked good for Abby. Abby was looking pretty good that day, right? The court looked like it was going to strike down the UT policy. They leave Grutter in place, but find the UT policy didn't go far enough. Went too far. Then Justice Scalia passed away. February, was it 13th, 2017? Might be off on the day. At that point, the majority dropped down. The court dropped down to 7 members in this case. And what happened then, I will love to read the papers of the justices, but something changed, right? And Justice Alito made this point in his dissent that something changed, right? In Fisher 1, we said apply strict scrutiny. And in Fisher 2, they said, well, that's strict enough. And they basically endorsed the reasoning of the Court of Appeals. And they then upheld the University of Texas's affirmative action policy. Someone's going to ask me, Josh, how do you reconcile Fisher 1 and Fisher 2? I don't know. I couldn't tell you. What does it mean going forward? I don't know. I can't tell you. The reason why is it's only a 4-member majority. And there's a long-standing debate about the weight of a 4-member majority, right? Justice Scalia was replaced by Justice Gorsuch. If Justice Kennedy retires and replaced by conservative justice, then I don't think Fisher 2 has much weight. If Justice Kennedy is replaced by a more liberal justice, Fisher 2 is probably safe. What I do know is that the court is not in any hurry to get another education case because they're very divisive. But as it stands now, there's virtually no scrutiny of affirmative action policies under Fisher. But Abby's not done yet. Well, Abby's done, but her friends are not. The same group that brought the Fisher case filed another lawsuit last year against UT Austin in state court. Whoa. We have a state constitution. We have a state equal protection clause that's more stringent than the federal constitution. And this case is working its way up to the Texas Supreme Court only on the state ConLaw issues, not the federal. So I think UT's policy may actually be affected yet. They're not done. The same group, of the second wit, filed lawsuits against Harvard and UNC. saying that their policies are exclusionary towards Asian Americans, right? The same stuff that Alito raised in his dissent. They're saying that Harvard basically has an anti-Asian quota, right? If you're Asian, it's basically impossible to get to Harvard unless you have a perfect SAT, right? They basically exclude them. It's pretty egregious and very blatant too. And so, wait, Josh, Harvard's a private college. They're not subject to the 14th Amendment. You're right, but they are subject to the Civil Rights Acts, which limit discrimination for schools that take federal money. So this is not yet over. And what was that? What was that? Oh, shit, what is it? Louder, I can't hear.
But they look everywhere to like get them. That's what I'm laughing at.
Yep, they found them. Harvard's probably the worst, But anyway, so those cases are bubbling up to the Supreme Court, and I predict that when those cases get to the court, there'll be a different composition. So, Fisher 2, cool now. I don't know what's going to be for the future. I saw a few hands. What was your hand up?
I was just wondering, in the case with UT in state court, do you think that the school will try to invalidate anything about the Texas Constitution not being consistent with?
Oh, leave it to the people in Austin to strike down the Texas Constitution, right? It's like a foreign nation. I don't know. It's a good question. I don't think they're trying to strike down the Texas Constitution as invalid the federal Constitution. I think that'd be really tough. There's another case called Schuette, which it's spelled Schuett. I didn't assign it, but it's referenced. I think that Michigan was allowed to amend their constitution to get rid of affirmative action, but I think Texas would likely be able to have the same power. Not that that's why the amendment was given. So my short answer for you is I think to this moment, Grutter is still good law. Fisher 2 is still good law. I don't know what its validity is going forward, but I think that's good law for you today. Yeah, Clinton.
What is the difference between Fisher 2 and Grutter then?
I think Fisher 2 is even more deferential than Grutter, right? I think Grutter at least left open the possibility that there could be some skepticism of an administration's policy. Okay. Fisher 2 is basically saying we're going to defer to the institution and we're not going to second guess. And this is why I think this is the Thomas dissent, right? This can't. Grutter wasn't strict scrutiny. Fisher 2 is definitely not strict scrutiny, right? O'Connor could at least maybe pretend that Grutter was strict scrutiny. It's hard to pretend at this point that the Fisher decision is application of strict scrutiny. Make sense, Clint?
Yeah.
It's not clear, and you have to understand. This is why I put the little blurb at Scalia's passing there. You can't understand Fisher unless you understand Scalia's passing. If Scalia was still alive, this case would have gone the other way. I'm fairly confident. In fact, I know the lawyer who argued Fisher. He's a friend of mine. He went to my same law school, and I saw him a couple days after. So I was like, "Dude, Will, what the hell happened?" He's like, "I don't know what happened. It was this weird thing." And now it's in your book now. Chase.
One thing I can't wrap my head around is even if the court were found for Abby, she still wouldn't have been guaranteed an admission, would she?
Good question.
Why'd she waste all the money in court?
Well, so here was an issue, right? Here was an issue. Abby Fisher graduated. Why was she even in court? Okay, she was suing for a refund of her application fee. You know when you apply for college, you put down like $75, whatever, it's like a little $100 application fee. That was her. Was it 150? Okay, no, it was 75. I'm old, right? That was her standing. Her injury was the application fee. This is inside baseball. The Texas Solicitor General wanted to moot the case by refunding her fee and telling her to go away. UT didn't want to do. UT wanted this case. UT wanted the case to go up. So there was UT wanted. They wanted to win. I mean, they rolled the dice. But there was a serious question of whether she was even had standing because unlike Alan Bakke, who never got admitted, could still go to med school. She graduated. She got her bachelor's degree. She went to LSU. She graduated. This case took 6 or 7 years. So the next case, the one filed against in state court, instead of having a single plaintiff who's going to age out, they have a class of plaintiffs who, it's an organization, they always have people up and coming. In fact, they were recruiting high school seniors a couple years ago. I know one of the people got recruited. So they'll be there for a while. There is a note, though, because there's a doctrine called capable of repetition yet evading review. Here, I'll type it for you, right? Capable of repetition yet evading review. And I'm going to go over the exam in a minute, so you don't go anywhere yet. Capable of repetition yet evading review. So take abortion, for example, right? Pregnancy lasts 9 months. That's as long as it lasts. Okay? If you're an elephant, I think it's 18, but for humans, 9 months. You can't get a case to the Supreme Court in 9 months. So you can imagine, whoop, she's not pregnant anymore, therefore the case is moot. So the court has a doctrine that says, well, if there's a problem that can repeat itself, but because it's so quick it evades review, you can maintain jurisdiction. And I think Abby's case probably falls somewhere in there, although they risked it by doing the application fee as a basis of their standing. There's also the issue of sovereign immunity, right? How do you sue the state of Texas? Texas actually waived their immunity to the University of Texas, so you can sue them all you want. That case is not going away. All right, so let me summarize. Oh, yeah, Evan, please go ahead.
I thought you were going to... Well, you had us read the Freedman's Bureau Act.
Yes! Oh, good. Thank you for reminding me. I'm so glad you remember that. Why did I ask you to read that, Evan?
That was going to be my question. I guess because they gave preference to the refugees.
Not refugees, wrong word.
I'm sorry, freedmen.
Thank you.
Yeah, sorry. And gave them land.
Right. So here's Justice Thomas's argument, right? Justice Thomas argues, as did Justice Harlan, that the Constitution is colorblind, that it doesn't permit any sort of consideration of race. And he argues because of that, you have a colorblind Constitution, affirmative action is not consistent with the 14th Amendment. Thomas has never engaged this in an opinion. I really want him to eventually. At the time of the ratification of the 14th Amendment, there was something called the Freedmen's Bureau Act that gave specific benefits to the freedmen, the freed slaves. Can the 14th Amendment be consistent with providing race-conscious measures? And the Freedmen's Bureau, I think, provides somewhat of a rebuttal to the Thomas opinion. I was really hoping Thomas would address this in Fisher. He didn't. Maybe he'll get to it eventually. I don't know. And for another class, but that's why it's in your casebook. Thank you, Ronnie. Clinton.
Freedmen's Bureau was overturned, though, right? They took all that stuff back.
They did.
Okay.
And what does that mean?
I would say that kind of takes the standing or the argument that it, that it was, I understand they may have done it originally, but they took it back. So the same people who created the 14th Amendment reversed the 14th Amendment.
Maybe it went too far.
Yeah. So I think it rebuts the opinion.
So then Thomas is safe, you think?
Yeah.
Maybe. Let me summarize. Right, the Freedmen Bureau is a fascinating history. I don't have time to go into depth, but it's an open question. So look, you have these 3 tiers of scrutiny, and what I'm going to do is I'm going to go to the exam. If you want to leave, you can leave, but I'm going to go past 40. But I will probably good use of your time. When you have an equal protection case, you got to do a few things, right? First, ask yourself, what is the classification? Is it age? Is it race? Gender? Whatever it is. Once you know the classification, you have to ask yourself, is this a suspect classification? Is it a quasi-suspect? Or it's age? For your purposes, if it's race or nationality or religion, it's strict. It's a suspect. Gender is probably the only quasi-suspect we'll have, and everything else is rational basis for non-suspect. Okay. Once you know the kind of classification is, you say, what's the appropriate test? Okay. And it's not enough for you to mechanically recite these tests. You have to discuss on your exam, or otherwise, what is the nature of the fit? How close is it? Is there some reason why this might be the case, right? Will this be the case for intermediate? Must it be the case for strict scrutiny, right? You know, that's actually better like must it be the case? You know, will it be the case? And might it be the case? I'll repeat this. That just occurred to me. It's a good way of explaining it, right? Might it be the case that this law will serve the purpose, right? Might. With intermediate, will it be the case? Probably, right? Maybe yes, maybe no. And this one, must it be the case that this will happen? That might be one way of thinking about it. But you need to walk me through this in the exam. It's not enough merely to just recite the standards of review. Okay. I'll go over the exam in a minute, but any questions on the actual content of today's class? Let me do this now. You get your exams tomorrow. If I don't do it now, you're going to panic, and it'll be easier to do it now. All right, so let me pull up the exam. If you want to go, you're welcome to go, but I suggest you don't. I can't force you to stay. I can never force you to stay. I lack that power. So the exam, the midterm, which again, you'll get it back tomorrow. I don't know what time, but you'll get it back some point tomorrow, whenever Terry finishes printing them out, is actually a real historical event. And it involves the Louisiana Purchase. We discussed this when we did Dred Scott, which I think we covered right before the midterm. So I actually mentioned this at various junctures in the semester. Okay, the first thing you have to keep in mind with this question is the year is 1803. I warned you so many times you should not be citing cases that come after 1803. Half of you did. I don't know if you just weren't listening or you panicked or what, but about half of you did the exact opposite thing I told you to do. Look at your year. You should not be citing later. There's no reason to. I don't want you to. The second thing, the setup for this question, as you'll see, is that you're addressing an issue for the Attorney General. This is not a court case. I don't care what John Marshall thinks. I don't care what the Supreme Court will say. That's not relevant. You're being asked as an executive branch official to decide this case. Be very careful. About half of you said, well, the Supreme Court will do this and that. That's not relevant. It's not part of the question. I took points off for that. So if you wrote about more recent case, I took points off. If you wrote about the Supreme Court, I took points off. It just wasn't relevant. What I did want you to do, and if you look at every question, use the exact same words, is please discuss all relevant provisions of the Constitution that may or may not grant such authority. This was an exam about the text of the Constitution. I want to see if you paid attention and you know your clauses, if you've been keeping your Constitution in class, right? If you just gave me cases, you're going to get a mediocre score. In fact, there weren't any, and maybe one or two cases have been decided by 1803, but I don't think they were relevant. Chisholm, maybe one other. So let's walk through these one at a time. And I'll post an A+ answer, I think, later tonight or tomorrow morning, but I'll send this to you shortly. Okay, so the year is 1803. President Jefferson sends 2 ambassadors to France with instructions to purchase New Orleans for $10 million. However, the ambassadors learned that Napoleon, Emperor of France, would sell the entire Louisiana territory, which is basically the entire Midwest, for $15 million. The ambassadors worried that Napoleon, who was embroiled in costly European wars, would revoke the offer if they didn't agree immediately. Okay, now, communication, right? There was no phones, there was no telegraph, there was no way for the ambassadors to communicate this message back to D.C. There just wasn't time. Nonetheless, without express approval, that's a key word, express approval, the ambassadors signed a treaty between the United States and the French Republic on behalf of the President of the United States. Jefferson would only learn of the treaty, which became known as the Louisiana Purchase, months later. This actually happened. This is an almost exact rendition of what happened. So I'm not making stuff up. I usually make stuff up. This one was right from the history books. So the first question asks, did the ambassadors have the authority to make this purchase for $15 million? I'm going to walk you through a number of clauses that you should have discussed. I count at least 5, maybe more, but at least 5 clauses of the Constitution you could have discussed, right? And it's helpful if you write Article 2, Section 1, right? The vesting clause. What's the vesting clause? It gives the executive power to a single unitary executive. One of those powers is the power to make treaties, which is also in Article 2, Section 2, right? But think about it. Is the president expected to travel by himself to every far-flung country and negotiate? Or do his ambassadors have a range of discretion in making treaties? Right? It's not entirely clear that the ambassadors lack the power, because it would be impossible for them to communicate back and forth. There was just no way of electronic communications. There's also the opinion clause, Article 2, Section 2, where the president can seek the opinions of his officers, right? Should the ambassadors have submitted their opinion to Jefferson before signing it? There's also the issue of the appointments clause. When the president appoints an ambassador, what kind of power are they given? And there's also the take care clause, right? Is the ambassador's ability to negotiate a treaty without the president's consent consistent with the president's obligations to take care that the laws are faithfully executed? A number of you cited Federalist number 70, which speaks of a vigorous and energetic executive. This is from Hamilton. Okay? These are things you should be discussing. You'll look tomorrow at the specifics, but those are the clauses I want you to talk about. What was not relevant? The necessary and proper clause wasn't relevant. McCulloch v. Maryland, not relevant. Marbury v. Madison, not relevant. Completely irrelevant, a lot of you put it. I think you were desperate, I don't know. You put something. You actually lose points when you cite the wrong thing, so don't do that. Okay? Don't cite later in time stuff. Okay? Number 2. Okay, a little bit shorter question. Jefferson doubted whether the Constitution gave the federal government the power to acquire a new property. He questioned whether an amendment was needed. This was an actual constitutional debate, right? Does Congress have the power to acquire new property? And let me tell you, the answer is not entirely clear. There are a lot of provisions you could have discussed. One is the property clause, which I mentioned earlier, which says Congress has the power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. By the way, don't repeat the language of the clause because you're just wasting words. I know what the clause says. Just cite it, it's fine. Second, please number 1, 2, 3, 4, 5. It makes my life a lot easier. One of you just gave me a jumbled paragraph with any numbers. I don't know where one begins and when it. Don't do that. Okay, I know it's an extra word, one, but it's a well worth it word. So even though we discussed Dred Scott years later, you can talk about it, right? Does the property clause affect only property belonging to the United States at the time of the founding, or property that's subsequently acquired? That's not entirely clear. There's also Article 4, Section 3. Congress can admit new states, right? Does the power to admit new states imply the power to acquire new property? Maybe. We have the spending power, right? That Congress can pay the debt to provide for the common welfare. Does this mean Congress can allocate $15 million for Jefferson's purchase? We have the Foreign Commerce Clause, right? Is the acquisition of property from France an exercise of foreign commerce? Maybe. We have the Appropriations Clause, that only Congress can withdraw money from the Treasury. If you need to go, just go. I'm going to keep going, and you can watch the video later. No problem. But then we have the Sweeping Clause, right? The Necessary and Proper Clause. Does the power to admit new states imply a power to acquire new property? And I think that's the strongest answer, that the Property Clause, in conjunction with the Necessary and Proper Clause, gets you there. You should be discussing most of these cases. Most of these clauses. Again, McCulloch had not yet been decided. Dred Scott, not yet been decided. Gibbons had not yet been decided. Okay? I'll keep going. And questions we'll take afterwards. Let people get out of here. Question number 3. It says, President Jefferson relented and submitted the treaty to the Senate, which provided its advice and consent, right? Now, there's provision of the treaty that says that the inhabitants of the territory must be given citizenship, right? At the time, the territory was occupied by French subjects and people of African descent, enslaved and non-enslaved. This is important, right? Does Congress have the power to grant citizenship? Before the 14th Amendment, this question was somewhat up in the air. And we know about Prigg, we know about Dred Scott, which says people of African descent can never be citizens. But there's some clauses for you to discuss. So we have Article 1, Section 2 and 3. To be elected to Congress, you must be a citizen for 7 or 9 years. Right? Article 2, Section 1, the president must be a natural-born citizen. We even have the Diversity Jurisdiction Clause, right? Lawsuits permitted for citizens of different states. And we have Article 4, Section 2, that the citizens of the states are given privileges and immunities. Right? There are other clauses, though, relevant. There's a 3/5 clause, the Slave Trade Clause, the Fugitive Slave Clause, right? These are revisions suggesting that perhaps people of African descent aren't citizens. I would like you to discuss all these issues as well as the Fifth Amendment, right? Would granting citizenship to a slave deprive the slave owner of his due process rights, liberty or property interests? Right, this is the Dred Scott issue. Okay. Question number 4. The French subjects begin to sell slaves, and Congress enacts a maximum price for the sale of slaves. Right? This is a discussion of the Commerce Clause. Don't cite Wickard. Don't talk about substantial effects. These tests did not exist yet. You can talk about what is the meaning of commerce. So it's like Gibbons, right? What is commerce among the states? Was a sale of property in the territories among the states, right? This is actually a very important threshold question. Also, was it a violation of liberty of contract? Did the Fifth Amendment even have a liberty interest that involved the sale of slaves? So that's what's discussed. The last one I'll talk about during your meetings. This was a policy question. But the question was, did Jefferson have to submit an amendment? What are the pros and cons? Well, if you submit an amendment, that suggests that the earlier actions were unconstitutional. But if you also submit an amendment, you're sticking to the rule of law. I'm going to stop there, let you guys go. Questions come up, or during review sessions. Thank you so much.